The Senate Committee on Public Safety will come to order. We will be starting as a subcommittee. So I do just want to say good morning. The Senate continues to welcome the public in person and via the teleconference service. For individuals wishing to provide public comment, today's participant number is 877-226-8163, and the access code is 6948930. We are holding our committee hearings here in room 2200 in the O Street building. I ask all members of the committee to be present in room 2200 so we can establish our quorum and begin our hearing. We have 19 bills on today's agenda. 4 are on consent. Before we hear presentations on the bills, we're going to have to establish a quorum, but we were going to begin anyways as a subcommittee. So I do just want to say we are going to ask for our first presentation of SB 94 by Senator Cortese. Senator, you have the floor.
Thank you, Madam Chair. Chair and Senators, I'm pleased to present SB 94, sponsored by the LWOP Center and a recidivism coalition, the California Coalition for Women Prisoners, and others. SB 94 would allow judges the ability to review death penalty and life without parole sentences for individuals who have served at least 20 years of their sentence and were sentenced for offenses with special circumstances committed before June 5th, 1990. These cases represent a very narrow population that consists of the most elderly individuals behind bars. Many of these individuals have shown decades of exemplary behavior, participated in extensive positive programming, and have devoted themselves to becoming positive members of society. Additionally, research shows that elderly individuals typically do not reoffend and do not end up back behind bars. For individuals previously sentenced to life without parole who were granted a commutation and released, the recidivism rate is actually 0%. To quote Robert Weisberg, co-director of the Stanford Criminal Justice Center, if I may, there aren't a lot of 72-year-old linebackers in the NFL. There aren't a lot of 72-year-old violent criminals because people age out. Weisberg has also noted that by far the most expensive prisoners to keep in prison are the oldest ones because of the health care costs. It costs about $106,000 per year to keep the average person in prison, but older inmates cost 2 to 3 times that amount. Also, let me be clear. This bill does not automatically let people out of prison. It does not guarantee resentencing. It is not a get-out-of-jail-free card. The bill simply creates a process for the judicial review of cases that have not been looked at in decades. Again, the bill simply creates a process for the judicial review of cases that have not been looked at in decades. If we believe we have a rehabilitative system, I think the question is, why wouldn't we go back after multiple decades and see if any actual rehabilitation has occurred? And why wouldn't we trust a judge to make that assessment? Under SB 94, courts could consider old cases in light of changes in law and apply the law more fairly. Judges would have the discretion to leave the sentence unchanged or resentence a person to become eligible for parole. This is a crucial bill when you consider that the legislature has enacted several reforms in recent years that restore judicial discretion. One such reform is allowing judges to consider mitigating factors, such as whether the person was a victim of intimate partner violence or human trafficking or had experienced child trauma, exploitation, or sexual abuse. As a result of these changes, people who received extreme sentences decades ago would not be sentenced the same way today. We want to extend those rights, that consideration, that defendants receive today to elderly inmates who didn't have the opportunity to assert those rights or those considerations when they were sentenced decades ago. With us today is Judge Harlan Grossman with the California Judges Association. I understand he will be our first lead witness, and Cheryl Lamar with the California Coalition for Women Prisoners, again, both here to speak in support Thank you, and at the appropriate time, I'll respectfully ask for your aye vote.
Thank you. Now let's hear from the lead witnesses. Please come to that mic and state your name, organization, and your testimony.
My name is, good morning, I'm Harlan Grossman. I'm a retired judge from Contra Costa County. I have to make one correction. I'm not here as a member of CJA or on behalf of CJA. I don't speak for CJA. I retired 11 years ago after 21 years of judicial service. I was a prosecutor for 9 years before becoming a judge and a special agent of the FBI for 6.5 years before that. Since retiring, I've been active in criminal justice policy advocacy. I'm here this morning to urge the committee to vote in favor of Senate Bill 94. This bill creates a process for judges to reconsider LWOP and death sentence cases where the crime occurred prior to June 5th, 1990, and the defendant has served a minimum of 20 years in custody for the crime. LWOP went into effect in California in 1978 as part of the Briggs Initiative. It was enacted in conjunction with California's reinstatement of the death penalty. LWOP is basically a lock them up and throw away the key approach to sentencing. LWOP's enactment marks the beginning of the tough on crime era where, over the years, legislators and ballot initiatives outdid themselves in proliferating tougher and stricter sentencing laws. California's tough on crime approach has led to mass incarceration, prison overcrowding, and the warehousing of prisoners. It has exacerbated the disparate treatment of people of color and their overrepresentation in custodial populations. Since 1994, there have been many true reforms that have evidenced a more enlightened approach to criminal justice. These include the drug court movement, the restorative justice movement, and the recognition of youthful offender status. These reforms give meaning to Dr. Martin Luther King Jr.'s quote, "The arc of the moral universe is long, but it bends toward justice. However, the arc has not bent enough. The arc needs to bend to include those sentenced to LWOP and death. Senate Bill 94 is a step in the right direction. The bill offers such prisoners a chance for redemption. Senate Bill 94 affords all the parties, the defendant, the people, those enacted by the crime, due process. Again, I urge this committee to vote to enact Senate Bill 94. Thank you.
Thank you. Do you have any other lead witnesses? Thank you. State your name, your organization, and your testimony. Thank you.
My name is Cheryl Lamar, excuse me, and I am working for CCWP. After being commuted by Governor Newsom, and I came home December 2020 after serving 34 years of a double LWOP sentence. Decades of self-motivated rehabilitation allowed me to understand my childhood impact on my life. For example, being abandoned by my mother at 1 month old and being molested by family members by the age of 9. And so I took full responsibility for my healing. Had I still been inside today, I would be eligible for SB 94 should it pass. SB 94, as Katerzi said, would be restorative judicial discretion, allowing judges to review cases, and they were imposed like in 1970s and 80s. This bill does not guarantee a get out of jail free pass, but allows the judge to decide the eligibility. Realizing that there's no parole option available for me, I still exhibited decades of exemplary behavior, participated in self-motivating, self-help programming, working to understand the root cause of my behavior, to be truly accountable for my actions. It changed and transformed me, and I devoted myself to becoming a positive member of the community inside the justice system. My sentence told me that I had no hope or chance, yet I maintained hope. Society had written me off as worst of the worst, yet I have proven that it is possible to re-enter society and become a productive member dedicated to giving back. After spending in my entire adult lifehood inside, I know there are so many elderly LWOP people and death penalty people that are doing positive programs or too sick to even work. They deserve a second look. SB 94 would be beneficial for the public health and safety in our budget. I urge you to take this into consideration and pass this bill. Thank you for your time.
Thank you. Now let's hear from other support witnesses here in room 2200. I want to be very clear that just state your name, your organization, and whether or not you support. We have 19 bills, so we're going to ask that everybody moves quickly on this. Thank you. Yep.
Natasha Minsker, Smart Justice California, and the Prosecutors Alliance of California in strong support.
Thank you.
Leslie Caldwell Houston for the California Public Defenders Association in support.
Joanne Shear on behalf of Felony Murder Elimination Project in strong support.
Good morning, Glenn Backus for Ella Baker Center for Human Rights. For efficiency, rather than have people call in, I have a short list of groups that would like to be in support. Santa Cruz Barrios Unidos, Indivisible California Stay Strong, American Friends Service Committee, Families Over Everything Else, Communities United for Restorative Youth Justice, the Empowering Pacific Islander Communities, Showing Up for Racial Justice Bay Area and Solitary Santa Cruz County, Showing Up for Racial Justice at Sacred Heart, California Native Vote Project, the Transformative In-Project Work Group, In-Prison Work Group, and Lawyers Committee for Civil Rights. Thank you.
Thank you.
Daniel Chawfield on behalf of Felony Murder Elimination Project, along with registering support, along with Center for Employment Opportunities, Uncommon Law, Decarcerate Sacramento, Starting Over, California Coalition for Women Prisoners, Human Rights Watch, National Harm Reduction Coalition, Young Women's Freedom Center, Families United to End Life Without Parole or Fuel, the Drop LWOP Coalition, and Jesse's Place. Thanks.
Thank you.
Melanie Kim, San Francisco Public Defender's Office in support.
Kelly Savage Rodriguez. I work for California Coalition for Women Prisoners and the National LWOP, National Life Without the Possibility of Parole Leadership Council. I'm a former LWOP, and I appreciate your guys' time. I also want to add some names: the California Safety and Justice, Drug Policy Alliance, California Alliance for Youth and Community Justice, Center for Juvenile and Criminal Justice, White People for Black Lives, ACLU, California Action, Initiate Justice, Holy Cross Lutheran Church in Livermore, National Harm Reduction Coalition, and Bend the Arc.
Thank you.
Daniel Landsman on behalf of FAM in strong support, along with organizations that have asked me to register support. Indivisible California State Strong, Legal Services for Prisoners with Children, Asian Prisoners Support Committee, Restore Oakland, Inc., Transitions Clinic Network, San Francisco Public Defender's Office, Fair Chance Project, California Families Against Solitary Confinement, Root and Rebound, Friends Committee on Legislation of California.
Thank you.
Hi, my name is Erin Catherine McCall, and I am here in strong support for Underground Scholars Initiative at UC Berkeley. Thank you.
Hi, my name's Elizabeth Brown, and I'm here in strong support with Underground Scholars Initiative for UC Berkeley.
Good morning, Andrea Mavisca on behalf of the California Immigrant Policy Center in support.
Good morning, April Grayson, Sister Word Freedom Coalition Policy Associate, proud co-sponsor and strong support.
Good morning, Anthony DiMartino, Californians for Safety and Justice in strong support.
Michael Garcia, Underground Scholar Initiative, and strong support.
Jared Harper, Friends at Work, and strong support.
Thank you. Are there any other support witnesses here in this room? Seeing none, we'll now move on to witnesses in opposition in this room. Please just state your name, your organization, and your testimony. 2 minutes.
Good morning. I'm Jason Anderson, the District Attorney for the County of San Bernardino. I'm here to express my opposition to SB 94. There are three foundations of our criminal justice system: notice, separation of powers, and finality. Notice tells us what the consequences are for our legal conduct, including murderers who exhibit particular evil, so that special circumstance punishment attaches to that criminal conduct. Separation of powers provides for our jury system. It's one of the most unique and purest forms of democracy that we have. While DAs decide to seek either the death penalty or LWOP, only a jury can decide guilt and recommend a death or LWOP sentence. Even after one of those sentences has been determined by a jury, Special circumstances cases undergo extraordinary appellate scrutiny for decades. Finality allows victims' families to rely upon the jury system and the appellate review in order to have some sense of justice and closure in a case, as does Marcy's Law. SB 94 undermines all three foundations of our criminal justice system. SB 94 does not promulgate justice, it actually dispenses and ignores it. Kevin Cooper, a case in San Bernardino County, was fleeing a charge of raping a young woman at knife point when he murdered Doug and Peggy Ryan, their young daughter Jessica, a neighbor Christopher Hughes, who was enjoying a sleepover at the house, and he also tried to murder young Josh Ryan. Even Governor Newsom's innocence investigation into Kevin Cooper declared that Cooper's guilt is conclusive and exhaustive. He's never admitted what he did. How could he be rehabilitated under SB 94? SB 94 could grant Kevin Cooper relief. Brian Mincy tortured and murdered a 5-year-old son of his then-girlfriend. Some of the victim's injuries included the shearing of the boy's anal tissue after Mincy forced a board into the boy's buttocks. SB 94 could grant Mincy relief. SB 94 should never make it out of this committee. Thank you.
Thank you. Do we have any other lead opposition witnesses? 2 minutes only. Thank you.
Thank you, committee chair and members. My name is Linda Thompson, and I lost my sister in January, my sister Sharon, in January of 1979. Sharon was moving out of the duplex she shared with 3 other girls New Year's Day. New Year's Eve, someone entered her home, tied and bound Sharon up, raped and sodomized her, and then slit her throat. She was 20 years old. The torture and terror she felt and endured is unimaginable. I witnessed the crime scene and have had reoccurring nightmares since. We waited 23 long years for justice. Authorities had finally caught up with Sharon's killer in 2002 after DNA evidence linked him to her murder. He was at that time in custody for another murder. At the time my sister's case went to court, I agreed with the plea bargain as he was sentenced to life without the possibility of parole. 30 years after Sharon was taken from us. We waited so long. Our dear mom passed away 2 months before we were told of the arrest. The SB 94 would change what I believed and have taken comfort in all these years, that my sister's murderer would never be released from prison. SB 94 changes the goalposts in an unjust manner. People convicted of special circumstance murder are the worst of the worst, like the person who killed Sharon. My sister deserved to live her life. She did not get a second chance. Thank you.
Okay, before we move on to any other opposition witnesses, can we call for roll call?
Wahab?
Here.
Wahab here. Tobog?
Here.
Here. Bradford? Skinner? Weiner?
Present.
Weiner here.
A quorum has been established. Now we will hear from opposition. Please state your name, your organization, and that whether or not you support or oppose in this fact, oppose. And we are going to move quickly through this. Thank you.
Good morning, Madam Chairperson. My name is Matthew Recco, in strong opposition on behalf of the San Diego Deputy District Attorneys Association, as well as the San Diegans Against Crime.
Thank you.
Good morning. My name is Tin Ho. I'm the elected district attorney for Sacramento County. I'm also here on behalf of Morgan Geyer, who's the elected district attorney of Placer County, and we are in opposition to SB 94. Thank you.
Good morning. Ivy Fitzpatrick, Managing Deputy District Attorney from Riverside County. I'm here representing the California District Attorneys Association, as well as the Riverside County District Attorney's Office, in strong opposition. Thank you.
Good morning. Randy Perry with Aaron Reed and Associates on behalf of PORAC and the California Association of Highway Patrol in opposition. Thank you.
Good morning, Madam Chair and members. Matthew Seiberling on behalf of the Association for Los Angeles Deputy Sheriffs in opposition. Thank you.
Thank you.
Morning, Madam Chair and members. Ryan Sherman with the Riverside Sheriff Association, also in opposition, as well as the Police Officer Associations, Claremont, Corona, Pomona, Palos Verdes, Newport Beach, Upland, Santa Ana, Burbank, Murrieta, Arcadia, Riverside, Fullerton, Culver City, Deputy Sheriff's Association, Monterey County and Placer County, and Los Angeles School Police, all in opposition to the bill. Thank you.
Thank you. Seeing no other opposition witnesses here in this room, we will move on to witnesses to testify via teleconference service. Please just state your name, organization, and position. Moderator, if you please prompt the individuals waiting to testify in support or opposition. We will begin.
Okay, and if you'd like to speak in support or opposition of this bill, please press 1 and then 0. We'll go to the line number 14.
Good morning. Rebecca Gonzalez with the National Association of Social Workers, California chapter, in strong support of this bill.
Thank you. Next, we'll go to line 24.
Good morning. Jim Lindberg on behalf of the Friends Committee on Legislation of California and also on behalf of the California Catholic Conference in strong support. Thank you.
We'll go next to line 23.
Good morning. Sherman Azami with Initiate Justice Action in strong support.
We'll go next to line number 19.
Good morning. I am Elaine Bisset calling on behalf of San Diego County District Attorney Summers Stefan. We are in strong opposition. Thank you.
We'll go next to line number 8.
Yes, my name is Tamara Alexander, and I am calling on behalf of my husband, former NFL defensive back Kermit Alexander, in memory of his mother, Ebora, sister Deetra, and 2 young nephews, Damon and Damani, who were murdered execution-style early morning hours of August 31st in 1984 for a murder for hire that had gone very badly. Maybe 72-year-old linebackers don't play in the NFL, but 82-year-old NFL defensive backs never forget. We are vehemently opposed to SB 94. Thank you.
We'll go next to line 12.
My name is Lauren Pettigrew. My brother is murder victim David Pettigrew in strong opposition.
We'll go next to line 25.
Good morning. My name is Sharita Moore. I'm calling on behalf of California Attorneys of Criminal Justice in strong support.
We have no further in queue.
Thank you. Thank you to all our witnesses. We'll now bring the discussion back to members. Members, do you have any questions or comments?
Yeah.
Senator Ochobog.
Thank you, Senator Cortese, for being here this morning, and thank you to all the witnesses, both in support and opposition for hearing. It's really interesting to hear the different arguments and the on both sides, and I think it's a really hard issue because we're dealing with humanity and whether or not there is hope on some of the issues that are here. I do have a set of questions that I have been asked to ask for the record, and let's begin with the first one that states the definition of special circumstance and what kinds of aggravated murder does this bill address?
Well, this special circumstances list that you're referring to is enumerated in statute, and that's what's addressed in the bill. This bill doesn't change that list whatsoever.
Okay. Are there any excluders for extremely horrific cases? Question being, would Charles Manson and Richard Ramirez, if he were still alive, be able to pursue relief under this statute?
Yeah, I think that's a great question and important, especially after listening carefully to the lead opposition, which I think all of us do as senators, especially in first committee hearing in case there's amendments or modifications that we want to make. But one of the things I picked up on was that somehow SB 94, if signed into law, would in effect release people, would release inmates. SB 94 won't and can't release anybody the way it's written and the way it will stay written. What it does is it creates a petition process so that if eligible under those petition criteria, a person like those that you mentioned could in effect have a hearing. I can't imagine any judge releasing as a result of an SB 94 hearing, Charles Manson. That's my my opinion, but that's my opinion based on having been a criminal defense attorney at one time, and it is a very, very difficult challenge to get a judge who is concerned about a reoffense in the future to consider any kind of a lesser sentence, other than what's before him or her. So again, this bill doesn't, as I said at the outset, does not release or automatically release anyone. It just creates a hearing process. It's quite conceivable that through whatever hearings occur as a result of this bill, that nobody would achieve a resentencing based on a judge's concern during that hearing that there could be a reoffense. I mean, that's the real question: is do we trust the judge, after 2 decades of incarceration, to make that decision?
Thank you, Senator.
And I want to just acknowledge that Natasha Minsker, who introduced herself earlier for Smart Justice, is here, who's an attorney who is available to answer questions in more detail. So if you're unsatisfied with the detail of my responses, please pivot over to Natasha. Thank you.
We had the pleasure to meet earlier, and I often use the experience that we had visiting with the LWOP prisoners in Lancaster as basis of my understanding of, furthering the criminal justice system and understanding it a little further. So thank you so much for that opportunity. I'm just taking that opportunity since you're here, but I appreciate the educational experience. So I'll open it up. Senator Cortese, I have about 2 or 3 more questions. This one's a little long, so bear with us. Many of the eligible defendants received their death or LWOP sentences after a penalty phase trial held before a jury. During these penalty phase trials, the jury considers much of the mitigating circumstances enumerated in your bill. The jury's sentencing verdicts for these defendants were then reviewed by the trial judge and thereafter upheld by the 7 justices of the California Supreme Court and even the federal courts, including the U.S. Supreme Court. In the habeas corpus process, defendants usually present mitigation evidence that they believe should have been presented at their trial and argue it would have made a difference in the sentencing decision. Meaning, for the last 30 years, mitigation evidence has been considered by the courts, and these defendants' sentences have been upheld by multiple layers of judicial oversight. This bill would now allow a single judge to dispense with these 30 years of multiple judicial determinations. What is the reasoning behind this approach?
Thank you. And let me just say, on this one, I'll answer it sort of at a higher level and then ask Ms. Minster to respond at a more detailed level in terms of the process that you just outlined. Nobody is contesting any of the decisions, the rulings, verdicts, judgments, et cetera, that have occurred in the process that you just outlined. What this bill says is one more thing. After more than 2 decades in prison, there should be at least an opportunity to petition for a recall of that sentence at that time. It doesn't challenge the validity of anything that occurred prior. It simply says there has been a rehabilitation process that's been occurring ostensibly. That's what we as legislators believe we have in our prison system. And after 2 decades, this adds one more step after those decades, which is the opportunity to petition for a resentencing hearing. No guarantee how that's going to come out one way or the other. I want to make sure I'm not misstating, so I want to turn to
That is all accurate, and it's a great question, Senator. The process we use in death penalty trials is, as you say, we have a special penalty phase where the defense presents mitigating evidence to the jury for consideration. Part of the challenge is that these cases are 30, 40 more years ago, and the standard of legal practice was very different. Part of the issue is that many of these people did not have quality representation. They did not have lawyers who actually presented the mitigating evidence in their case. There are 4 people in this room here today who were sentenced to life without parole, and their attorneys did not present the mitigating stories and evidence in their case, things like the childhood sexual abuse that they experienced, right? And so part of the reason death penalty cases, why the litigation continues for decades, is because we don't have quality attorneys, especially 30 and 40 years ago, we didn't have quality attorneys that presented this information to the jury. And when we see these cases unfold over decades of litigation and the habeas process where new attorneys do present this evidence, then in 2 out of 3 cases, the sentence is actually reversed. So in California, if you are sentenced to death, the most likely outcome is that your case will actually be reversed on appeal for exactly these reasons, because this kind of mitigating evidence wasn't considered. And many people, in fact, die while their cases are in the review process because the process is so cumbersome and takes so long. So one of the key things about this bill is that it is about cases that happened decades ago, from before 1990, offenses that occurred before 1990, people who have served a minimum of 20 years, some of them have served 40 years. And it's going back and giving the judge an opportunity to say, what did we fail to consider the first time that we should consider now? And how have circumstances changed in the last 30 years that we should consider now? And it's really just about giving the judge an opportunity to consider that information.
Thank you. And then we have the following question, which states, how does the governor's clemency process intersect with this bill?
Well, it's a separate process, of course. We heard from one of the lead witnesses today who actually, I don't know if it's the right word to say, was the beneficiary after 34 years in prison, because it seems a little bit oxymoronic to say that, but after 34 years was commuted by the governor. She stated in her own testimony, of course, that had this SB 94 process been available, or if it were available in the future, people like her who might be commuted but haven't been yet would have a judicial process to go through. So yes, the governor, we heard a lot about the different levels of government and the separation of powers and everything else, the checks and balances. Our governor, whoever that may be, Democrat, Republican, or otherwise, considers commutations and has the power as an individual to weigh all those circumstances that we're talking about here and commute a sentence. We're simply saying that somebody wearing the robes as a judge who's qualified to weigh the exact same evidence and circumstances after this 20-plus year period, he should be allowed to weigh those circumstances. So it's again, as I said in the earlier question, not taking away from the existing framework that we have, but just adding another avenue or pathway for justice to be served in those cases where it's appropriate.
All right. And then I have one last question, and then I would like to hear a comment from one of the lead witnesses in response. As the author, are you envisioning any evidentiary hearing with witnesses and evidence being presented at each of these hearings? And what is the standard of proof required to establish a mitigating factor? Which party has the burden?
Let me turn that over to Ms. Minster to answer that technical question. Thank you.
Absolutely. The bill provides for hearings where evidence could be presented. Evidence could also be presented in test documentary form or through declarations. The moving party bears the burden of proof whenever the motion is made. So here the individual making the petition would bear the burden of persuading the judge that mitigating evidence existed. And then ultimately it is up to the judge in their discretion whether to resentence or not.
And through the chair, Madam Chair, would like to hear from the lead witnesses with regards to whether or not this information suffices.
In opposition, correct?
In support, I'm sorry, in opposition, yes.
Yes, okay, yes.
I'm sorry, yes, the lead witness in opposition.
30 seconds.
Go ahead, Rob.
Good morning, Madam Chair and Vice Chair and members of the committee. I am Robert Brown. I'm the Assistant District Attorney from San Bernardino County. I work for Mr. Anderson, and he brought me here to answer any questions. You're asking if the information that you put, if that was described just a moment ago, would suffice for what is being asked of the judge? It's difficult to tell because I've heard no standard of proof. We don't know what level that judge would have to find in order to grant relief or deny relief. So I don't know if that question could be answered under what's been described this morning.
Okay. Is there any other comments that you have with regards to or thoughts on the responses that were given today with regards to the questions that were presented?
As to those responses, no. I do have thoughts that there are two significant legal issues with this bill. I'm happy to describe those if you would like.
Are those addressing any of the issues that we addressed today here?
Not so far.
Questions? Okay. Through the chair, is your...
Yeah, we're going to move on to any other members who have questions or concerns. No senators. Okay, so Senator Wiener.
Just one question, which you've answered, but I want to just make this crystal clear. Does this bill mandate any judge to release anyone from prison?
No.
It sets up a process considering different factors and providing a path that the judge can evaluate the evidence and the circumstances and how the person is done in prison and so on and so forth, and then can make a determination.
That's correct.
And these are people who were incarcerated as of 1990 or earlier?
That's correct.
Okay, so we're talking about decades and decades in prison.
That's correct.
Okay, thank you. And I move the bill.
At least 2 decades, anyway.
Thank you. I do just want to thank all the witnesses who testified. I'm personally of the mindset of sometimes, as a victim of myself of, my father was murdered and it's a cold case. And so I often understand the feelings of victims, particularly wanting justice and wanting that individual to serve life without parole. I get it. At the same time, I also think that with the purview of the judge and at their discretion evaluating additional evidence over several decades of time being passed, potentially even more technology and support and understanding of what's happening, I think that it is sometimes a very good practice to revisit cases. And with nearly 40 years passing for some of these cases, what this bill covers, I think it's only right to at least have that in place. So I do appreciate it, Senator, for you bringing this forward. I appreciate everybody on both sides that have testified. I understand the emotional impact on families as well as those serving time. And I would like to have you close, Senator.
Thank you, Madam Chair, and appreciate that your eloquent comments. I, too, am very moved by the concerns and testimony that we heard here today that we call opposition testimony, but I suppose for those families is really support testimony in their own mind for something that they consider to be a very valid and solid legal process that's occurred up to this point. We're not trying to change what occurred up to this point in any of these cases. I suppose, again, having some lived experience in the courtroom, that some of the what attorneys would call fact patterns that we heard today, which are compelling and devastating fact patterns in terms of what happened, are the same fact patterns that would be compelling to a judge. This bill just simply allows a judge in the review process that we've been describing to make that decision if the criteria are met for a hearing. And with that, I'd respectfully ask for your aye vote.
Thank you. We have a motion by Senator Wiener to move this bill. Can we have a roll call?
SB 94, motion is to pass to appropriations. Senator Wahab?
Aye.
Wahab, aye. Otobo? No. Otobo, no. Bradford? Skinner?
Aye.
Skinner, aye. Wiener?
Aye.
Wiener, aye.
Thank you. This bill will be placed on call. Really appreciate it. Thank you to everybody. We'll be moving on to the